Hi there and welcome to Amicus Curiae. I'm Ashwin Mohan, and this week we're going to analyze the key takeaways of a very crucial verdict. The Gujarat High Court verdict in the case of Essar Steel versus RBI has hogged the limelight in the past few days as far as the legal and banking circles go. And to throw more light on what are some of the key messages to all stakeholders part of the Insolvency and Bankruptcy Code, I'm joined by two leading voices, two leading lawyers who are experts in the field of financial services. Dina, Wadia, Joint Managing Partner at law firm JSA, and Rajesh Gupta, Managing Partner at S&G and Partners. Dina and Rajesh, welcome to the show and thanks for taking out time. Dina, let me kickstart with you. You've closely tracked the banking and finance space for decades. Did you anticipate litigation at such an early stage of the IBC rollout in India? And this is considering the fact that the RBI flexed its muscles and in the absence of tough decisions by banks was forced to directly intervene in the entire stressed asset resolution process. And of course, what it did was that it shortlisted 12 corporates for immediate action under IBC. Essar Steel was one of them. Was this expected?
You know, the IBC is such a landmark legislation which marks a fundamental shift in the way that our insolvency and corporate restructuring is to be handled, that you are bound to get resistance and pushback from the corporates and even banks, which were hitherto not geared up to move in such manner. So when you have a new legislation which is such a marked shift from a debtor in possession model to a creditor in possession model, you are bound to see Indian promoters and corporates going to try and to some extent use all possible means to challenge the law.
Point noted, Dina. Rajesh, let me come to you now. Before we move on to analyze the main challenges that were posed by Essar Steel in this petition, I want to discuss an important observation in the fine print of the order, Rajesh. When the court asked RBI, based upon which office order or directions or decision the 13 June 2017 press release was issued, the RBI responded that pursuant to the recommendations of the Internal Advisory Committee, the regulator took the decision which is contained in the press release. The counsel also added during courtroom arguments that there is no other document in which the decision to issue the press release has been recorded. Now the judge has observed this in the order and has said, and I quote, "This goes to show the manner in which RBI is functioning," and has also called it, I quote, "a serious issue." Would you say, Rajesh, that the court has highlighted an avoidable administrative lapse by the RBI while dealing with a serious economic matter with consequences for the entire banking system? That seems to be the school of thought in some circles at least.
You see, with all due respect to the Honorable Court, there is a degree of restraint probably required in this serious situation when the country is facing the serious dilemma of such a large degree of NPAs. Certainly the court has an observation that probably before this press release was published, the Reserve Bank of India should have documented the internal committee decisions made pursuant to which the press release should have been issued. But in any case, this press release itself is a document or the statement made by Reserve Bank of India, which is binding. In fact, the validity of this press release has been sort of upheld by the court also. So probably it was avoidable, even if this was not referred to, still the importance of the document would have remained the same.
Right. Now that we have preliminary comments from both Dina and Rajesh, let's now proceed to the meat of the matter. Essar Steel had moved the Gujarat High Court challenging three specific moves. A, the decision of the RBI based on their press release dated 13 June, which directed banks to initiate proceedings against Essar Steel under the provisions of the IBC. B, the decision of the consortium of lenders to initiate a plea under Section 9 of the Insolvency and Bankruptcy Code. And C, failure of the consortium of banks led by State Bank of India to implement the package of debt restructuring approved by the Board of Directors of Essar Steel. Now, Essar's plea, of course, was the first instance of a corporate identified by the regulator for immediate referral under the IBC, which went on to challenge the manner for shortlisting it. But the Gujarat High Court has refused to provide any relief to Essar Steel and has not stayed any of the above moves or altered their status in its verdict. So, what is the message that has been conveyed to all stakeholders regarding the exact scope of powers of the RBI as well as banks under the IBC? Dina, would you like to take that?
The court recognized that RBI has the power as the banking regulator, and it is well within its powers to give such directions. See, with regard to SBI, I mean, you can say that, I mean, you know, does SBI, and quite frankly, or any bank which has NPAs and which have not been able to satisfactorily resolve the restructuring, you know, companies tend to, you know, draw them out long. We have been in many situations where, you know, these things just drag on for ages. So is it anybody's case that SBI as a secured creditor whose accounts are in default cannot approach the NCLT? Does it need RBI to tell it to approach the NCLT? I don't think so.
Right, Dina. Rajesh, would you also like to outline the powers of the RBI and the banks that have been specified as per the verdict?
As per the verdict, under Section 35AA, the Reserve Bank of India has been given powers where they can issue instructions to the bank to identify cases which are to be taken up before the IBC. So that particular part has not been negated by the court. So the supervisory power of the RBI therefore remains intact as it was. The bankers can identify those cases which they want to and wish to take to the bankruptcy under the bankruptcy code before the NCLT. So the bankers can identify those cases, take up those cases and initiate proceedings the which they want. The only issue probably which has been raised by Honorable Court is that as and when the matter goes at the admission stage, appropriate notice should be issued to the defaulters or to the borrowers, and their pleadings or their matter should be heard. Their grievances should be heard. They should be given an opportunity whether this proceeding which has been initiated is right or wrong, or there is anything wrong about it. So only from the perspective of opportunity, which is enshrined as a principle of natural justice, and that has been provided for, the rest the validity of the code has been maintained intact, and the powers of the bankers to go and file these petitions have also been upheld.
Right. Now that the all-important question of the powers of the regulator and the banks is clear, let's move on to another interesting aspect of the verdict. Essar Steel had argued that it had reached advanced stage of discussions with lenders on its debt resolution proposal. It argued that it had paid 3,000 odd crores to banks between April 2016 and June 2017, and also added that handing over the management of the company to a tribunal-appointed insolvency professional at this stage would make matters worse, and hence Essar Steel argued that it deserved to be in the category of companies which were given 6 months by the RBI to finalize a resolution plan. Do you think the RBI's cutoff date of March 2016 to assess the NPA status of the 12 companies for referral under the IBC needs to perhaps be justified more explicitly by the regulator to avoid any allegations of retrospective classification and it being immune to practical business realities? Dina?
See, I think there are a couple of things here. One is that, you know, there has to be some place to start. I mean, you can, whichever date RBI may have taken as a cutoff date or in identifying these particular 12, I mean, somebody would have had something to say about that. What appears to have been the rationale based on a reading of the judgments and the arguments that RBI put forth is that they have not, they have taken a little longer period. So they have taken a 31st March 16 date as a cutoff, which is, you know, good 15 months prior to sort of send the message that these are sort of long-term accounts which are troubled. They are very large accounts, and therefore you have that 5,000 crores and 60% cutoff. I mean, it is surely, you know, when you have something like at whichever date you pick, an excess of 35,000 crores, and even I believe, you know, the judgment reflects 45,000 crores outstanding. These are not small numbers, and this has been going on for a while. So I don't think it is fair to say that there was no sort of intelligible criteria on which RBI based it. But I think perhaps, one doesn't know, but there is always a learning to be gained, and possibly going forward, if RBI may decide, the directions always lay open the possibility that they may give further directions from time to time and lay down further rules from time to time. So it is entirely possible that they may, give some more grounds or give some further details of their investment advisory committee kind of meetings.
Rajesh, which side of the fence are you on as far as this RBI cutoff date is concerned?
Well, I don't think so, because all these borrowers who have been owing such large debt to the banking system have been exactly knowing all pain points. This has not happened or erupted suddenly. This pain process has been going for very, very long. All these borrowers have been well notified and well informed by the banking community of the stress around their accounts. So this is not something new or not something sudden. This has been a journey for a very, very long period. So I think the cutoff date has been very well planned, thought about, and then implemented. There's nothing wrong with it.
Right, Rajesh. Now, what's your take on the High Court's commentary on the manner in which the IBC has to be implemented? The order says, and I quote, "Provisions of IBC may be drastic to some extent, but since it's part of the statute, which is yet not declared unconstitutional, the provisions have to be followed, but in consonance with the constitutional mandate by all concerned." The court goes on to add that all provisions may not be treated mandatory, but it could be treated as a directive only based upon facts, circumstances, and evidence available before the authority. Does this finding, Rajesh, which forms part of the conclusion of the High Court judgment, take the sting out of the binding nature of the IBC and expose it to more litigation, where companies can present their unique facts, circumstances, and evidence to try and wriggle out?
I think yes and no. First of all, are there provisions drastic? To some extent, the provisions are drastic. We needed something to sail on. As it is, the problem has been so acute and high that unless some drastic measures are taken by the legislature and also by the banking community, also by judiciary to some extent, this menace of NPS cannot be checked. But the code is evolving. There have been some situations. There was one point raised whether the borrower has the capacity or ability to stand up and object at the time of admission, which point has already been clarified by the NCLT and now under the orders of Gujarat High Court also. So I don't think that by mere this remark the constitutional validity of the code would be questioned, but the probability of borrower going and challenging the code and challenging that it is ultra virus cannot be ruled out in any case. This judgment might give some ideas to the borrowers to examine whether the code can be challenged on the ground of constitutional validity. All of us know that when Wadia chemicals case happened, when SARFAESI Act had come, the constitutional validity of the Act and the virus had been challenged. In one single case, the whole of the matter was settled and the constitutional validity of the SARFAESI then was upheld. So therefore, even if this code is challenged, I don't think any danger is there with regard to its constitutional validity. Rather, if any borrower attempts that, it might actually put the whole controversy to rest. So the probability cannot be ruled out, but I don't personally think any adverse outcome of that action, if any, which comes up during the next few months.
Now, Dina, there is a part of this entire case between Essar Steel and RBI that the Gujarat High Court has decided that it is best taken care of by the NCLT. What do you make of the High Court's refusal to address Essar Steel's activities and exercise of restructuring through the JLF? Now, the High Court has said that that's the subject matter of the NCLT, but wasn't the debt restructuring program or progress claimed by Essar Steel one of the company's main arguments for claiming relief? So why do you think the High Court felt it was not appropriate to determine this aspect? Could you give us some more clarity as far as understanding the High Court rationale is concerned?
See, this is not, yes, you are correct, and it was the main ground also on which relief was also not granted. But the High Court is not the adjudicating authority, on whether a resolution plan is to be adopted or not. Neither is the NCLT. The person who is tasked with assessing whether a restructuring plan is to be accepted or not is the insolvency professional, and ultimately this power resides with the committee of creditors. So it is not the NCLT that has this power.
Dina and Rajesh, I'll have to request both of you to hold on to your thoughts because it's now time to slip into a short break. Stay tuned to ET Now and keep watching Amicus Curiae, where we continue to analyze the key takeaways of the Gujarat High Court verdict in the case of Essar Steel versus RBI. Welcome back to the show, where I'm joined by two leading corporate lawyers, Dina Wadia and Rajesh Gupta. Now, Rajesh, if you look at another aspect of the verdict, the High Court has also left it open to the NCLT to decide whether to admit the insolvency plea of SBI or Standard Chartered Bank against Essar Steel, and in fact has also clarified that a case being filed at the NCLT would not directly result in admission under the IBC. Now, that's a very significant clarification coming in from the Gujarat High Court. Does this, Rajesh, set an important legal precedent and highlight the onus which lies on the NCLT in such cases?
The High Court has been insistent that there should not be any mechanical process. I think what the High Court has interpreted is that if a case is filed before NCLT by any of the lenders, it should not be such that the case is just admitted without application of mind. The clarification or the interpretation given by Honorable High Court is that when such matter is presented before NCLT, a fair opportunity is to be granted to the borrower, and only a post-hearing, when it is examined that there is nothing adverse on the bankers to file such a matter or the lenders to file such a matter, the case should be admitted. So the thing to be followed is that as and when this matter is filed, before admission, a due proper opportunity, a fair chance of hearing is given to the borrower, which probably is the right way to take things. And if borrower has got some serious bona fide approach to this matter, where it can be established beyond doubt that the NCLT action was not maintainable, then let NCLT take that call at that point of time.
Right, Rajesh. Now, Dina, the Gujarat High Court has also observed that, and I quote, it would be appropriate for RBI to see that the benefit of all its schemes is equally offered and extended to all without any discrimination. Will this make things difficult, Dina, for the RBI to justify in a judicial forum why it's referring some accounts for bankruptcy and allowing others time to renegotiate? Do you see that as a potential challenge?
See, I don't think there will be any difficulty for RBI in justifying why some of its accounts are to be referred to bankruptcy or not. I think notwithstanding allegations etc. of discrimination also, which you need to make to be able to sustain a writ etc. The court has found that there was no classification in fact by RBI, and neither is it the criteria that RBI has used arbitrary or unjust. So one hopes that this argument will be put to rest.
Right, Dina. Now, Rajesh, the order might have denied any relief to Essar Steel, but it also wraps the knuckles of the regulator RBI, warning it to be careful when drafting press releases, which should not advise, guide or direct judicial or quasi-judicial authorities in any way. Now, during arguments, the RBI did regret what they called a drafting error regarding the portion of the 13 June press release which wanted the NCLT to accord priority to the 12 IBC cases. But the High Court demarcated the regulator's boundaries clearly with its warning, right?
Well, you see, on the lighter side, I think what irked Honorable High Court was that the earlier press release before modification stated or directed even NCLT to handle these matters on expeditious basis. Now, I think this is quite a fair observation. As a regulator, we can regulate what we have been authorized or permitted to be, but the executive certainly can't go to judiciary and direct them in what time frame the matter should be disposed of. RBI has gone on record to say that that was not the intent or design. I think it was a sort of faulty language which was used in the whole press release, which has been amply cleared before the Honorable High Court also. But yes, to that extent, Reserve Bank of India will have to be careful that they don't put any such material in the further press releases or notification which is in excess to the powers conferred on them, and certainly they can't direct judiciary to do certain things in certain manner. To that extent, the observation is correct, and I think Reserve Bank of India has already taken a good note of that observation.
Right, Dina and Rajesh, now that we have examined all the key and crucial aspects of the Gujarat High Court verdict, this is a question for both of you. What impact do you think the Gujarat High Court order will have on the pace of the IBC process, and do you think other corporates who are part of the 12 shortlisted cases will be tempted to challenge the RBI direction after this verdict, or will be in wait and watch mode to see what the NCLT does? Dina, let's start with you.
Difficult to say sort of what impact the Gujarat High Court order will have on IBC, but one thing I think it establishes very clearly that, you know, so long as the IBC and the jurisdiction of NCLT is not struck down by a higher court, this is pretty much here to stay sort of, and that it is not to say that some of the Indian corporates will not use their ingenuity to try and come up with different takes on some of the issues, or try to challenge on some slightly different ground. But I think it is sort of well established that that the NCLT is here to stay, the IBC is here to stay, that the courts are not going to interfere in determining whether a restructuring should happen, how it should happen, how NCLT should implement.
Rajesh, would you like to add to that?
You see, although the judgment of Honorable Court has been interpreted both ways to some extent, but in my view, the judgment has sent a very, very strong signal to the banking community as well as to the borrowers. The strong signal is that the actions being proposed under the code are legitimate and are maintainable before the NCLT. The banks have the discretion to decide what to do. The banks don't even have to wait for the recommendation to come from Reserve Bank of India. If in the wisdom of bank they feel that they need to proceed with the matter, they can certainly proceed. The second message, which is quite clear, is that if the action being initiated or proposed by the bank is owed to some kind of mala fide approach, that might be questionable. And a good message for the borrower is that if they have got a bona fide situation which they wish to put forward before the NCLT at the time of admission, they have the right to represent themselves. So that right has been recognized. But at the same time, as the petition has been dismissed, it's a very, very great and good signal to the borrowers, and particularly who are running such large NPAs, that it's not an easy cakewalk for them.
Dina, Wadia and Rajesh Gupta, thanks again for taking out time and joining me on Amicus Curiae. It was indeed a pleasure chatting with the two of you. With that, it's a wrap on this edition of Amicus Curiae. Thanks so much for tuning in. This is Ashwin Mohan signing off. See you next week.